We will go on the record in the matters 25 CM 113, 25 CM 185, 25 CM 216, State of Wisconsin versus Lee Moritz. The state appears through Assistant District Attorney Jose Vila in person. Mr. Moritz appears in person. I just noticed your shiner.
Yeah.
What happened?
Had an accident at home. Fell off a ladder.
That looks pretty bad.
Yeah, it's not good. It doesn't feel good.
Ouch. So Mr. Moritz appears in person with his counsel.
A courtroom plea hearing suddenly turns into a shocking victim statement. Years of alleged abuse, threats, and manipulation spill into the record, and the judge is watching every word carefully.
With his counsel, Joseph Rosenthal, by video conferencing. We're set for a plea and sentencing. Mr. Rosenthal, is this matter proceeding as such?
Yes, Your Honor. The defense is ready to proceed.
Okay. And Mr. Moritz, Mr. Rosenthal is appearing to your left on the video conferencing screen. At the last hearing, I believe you indicated and said that you are okay with him appearing by video.
Yes.
Do you understand? You do have the right to say, you know what, Judge, I want him to be seated next to me.
Does it really? Does it matter?
It doesn't matter to me.
No, we talked about this and saved us both time, you know. Why drive if we can do it by phone?
And money.
Right. Yes, absolutely.
But it is your right to have him in person. So
right. No, we discussed this.
And I want to let you know that if at any time maybe you can't hear him or see something that, or you can't see him or hear something that he's saying, let me know. I need to make sure you've heard and you've understood everything that happens, okay?
Yes.
And if at any time you have any questions or concerns and you need to speak with your attorney, let me know. And either I will adjourn the hearing and let you go give him a telephone call, or I will adjourn the hearing and put you into our Zoom room and put you into a confidential breakout session with him, okay?
Yes.
All right. So Mr. Rosenthal, what is the agreement that's been reached?
Your Honor, my client's going to plead to the sole count in 25 CM 113. The remaining two files would be dismissed and read in, and parties would be free to argue sentencing.
All right. Okay. Free to argue. I do have a plea questionnaire waiver of rights form. Mr. Rosenthal, you informed the court that you have filed it, but that it has not been signed yet, and you wanted the court to have that in front of Mr. Moritz. It was placed, Moritz, sorry. It was placed on his table and by the clerk, and he has reviewed that. And Mr. Moritz, is that the document that your attorney went over with you, those two documents?
Yes.
And so you reviewed them thoroughly?
Yes.
And did you sign those documents?
Yes, I did.
Okay. Now, can you please bring those documents? Well, why don't we go through the plea questionnaire, plea first. So you have them in front of you while we go over them, and then you can file them with the clerk. Victims' rights compliance?
Yes, Your Honor.
Will victim be making a statement here today?
Yes, Your Honor.
All right. The victim can come up here to the black desk, table desk. You do not have to tell your name. If you want to, you may. Otherwise, you can say your initials, okay? So you can come up here. And it looks like you have something that you may be reading to the court. I am just going to ask you to please read it slowly and enunciate your words. And if it is going to get emotional, just stop and take a breath, just because our court reporter needs to take everything down. So when you can speak slowly and enunciate and breathe, she's able to take everything down accurately, okay? All right, you may be seated or you can stand, whatever you prefer.
I have a question.
Yes.
May I read this exactly how it was said to me or stated at the time? There's some crude words and comments in here.
Yes, I will allow you to do that. I know that those are things that may have been, don't take this wrong, but allegedly said to you.
Yes.
Yes, so you may, if it has vulgar language or swear words or things like that, you may say the entire word and not be in contempt of court. Okay, I'm going to also ask you to take the microphone and have it more towards you.
Is that better?
Yes, you may begin.
Your Honor, I have spent months thinking about this the day I would get to stand in front of you and speak. I have written pages of my life and incidents with Mr. Moritz, and there was one statement they all had in common. He knew exactly what he was doing. Mr. Moritz knew exactly what he was doing every time he violated the restraining order. He lied and manipulated situations to avoid responsibility. He twisted events and told false versions of what happened, but one thing remained consistent. He blamed everyone else. He knew from the beginning he had a restraining order. I told him I was getting a restraining order for trespassing on my grandmother's property and taking my car from me. After that, he texted me to drive the only thing in my name to work tomorrow, leaving me my gas golf cart. But he didn't seem to care because his response was, do whatever you have to do. I have thousands of text messages where he stated things I wrote in the petition, how he knew he had a warrant, and stated, I asked you not to get the law involved. He avoided every court hearing. He would text me asking why cops were knocking at his door. He stated multiple times he didn't care about the restraining order. He ignored every police officer that told him to stop contacting me. He threatened me to drop the charges, telling me how small I am and what he can do when he's sober. He purposely avoided police for 8 months and continued to harass me. During this time, I felt unprotected by calling into the sheriff's department. The first time I called, the deputy that I got asked me, have you just tried blocking him? And the text messages that I sent to the deputy never made it to the DA's office. The victim witness coordinator told me there was a possibility of closing the case due to the missing documentation of the text messages. Mr. Moritz also told me his sister, who is a police officer, notifies him every time I call him in, and that he is above the law because of this. Whether this statement is true or not, I do not know, but I can say that there was information Mr. Moritz and his sister both knew about when I spoke to other police officers and jailers. One of the times Mr. Moritz was brought into jail. Along with Mr. Moritz's blatant disregard of the law, he also has a terrible drinking problem. Mr. Moritz buys a case of beer every day or every other day, as he puts it, when they're good days. He states he uses his beer as a medicine when he refuses to take any mental health medicine or pain medicine. He also says his doctor told him drinking his beer was just as good for him as any other option. I would be surprised if he blew a .0 here today. If you notice on the text messages submitted and other documents, most of the time Mr. Moritz starts harassing, threatening, and abusing around 4 p.m. He's had then hours of drinking in, and depending on his schedule, there are times when he doesn't sleep and drinks all night long and makes the situation even scarier. These patterns of abuse happened while the children and I were both in the home. Mr. Moritz repeatedly abused me and the children. This was not an isolated incident. It happened in different ways and continued to escalate over time. Mr. Moritz used emotional and verbal abuse throughout our relationship. He often insulted me and humiliated me, especially about my body. He would tell me things like, "You're disgusting," and told me he would only listen to me or seek help for his drinking if I maintained a certain weight. He often called me worthless and a cunt, and I could be replaced at any time. These were things he said in front of the children, teaching them to be disrespectful to me too. This happened regularly, and after arguments, he would deny or say I was too sensitive and that I shouldn't take what he does or says after a night of drinking too seriously. Tomorrow's a new day and you need to move on from it. He emotionally abused me to control and scare me. After my mother died of lung cancer, he taunted me about my smoking and told me to go kill yourself and smoke another cigarette like your mom. He told me I had no family left that cared about me and no one else would want me, so I'd better stay with him or I'd be alone. He also told me in front of my son that it would only take $10,000 to have me killed. These threats and cruel statements happened many times over the years. Mr. Moritz would also abuse the children. He'd call them names like stupid, bitch, fucking pussy, retarded bitch, pervert, fat ass, and blame them for problems in his life. There were physical incidents that happened, including throwing wood at his son and grabbing him by the throat. This behavior led to a CPS case in 2023, and instead of taking responsibility, he blamed me and the children. After my son was interviewed as part of the CPS investigation, Mr. Moritz threatened my son for telling the truth to CPS, stating, "I should choke you like you said I did to my son. Do you know how long it takes someone to turn blue?" Physical abuse was also a repeated pattern for me. He forced me out of our home on dozens of occasions, dragged me out of bed, locking me outside with no place to go. One time he dragged me out of the house by my ankles and locked me out. But then he called me the next morning when I wasn't home, asking me when I was coming home because he was horny. Another time he threw a tray of grease and fat at me and my son when we tried leaving, hitting us in the car. He's had his hands around my neck, pinned me in corners, threw my phone in the toilet and peed on it so I couldn't contact anyone. And at these times I had to fight back to protect myself. When I did fight back, Mr. Moritz would tell me would tell people, family and friends, he didn't do anything, and I just went crazy on him for no reason. When I was able to leave and get away from him, he would follow me in vehicles. He would show up where I was, follow me to stores and my family's homes. The times I could not leave were because he would hide my keys or even drive my car into deep snow so I couldn't move it. This behavior also happened multiple times and made both me and my child feel unsafe. Financially, Mr. Moritz has abused me by taking my car from me without permission, leaving me without a vehicle and no other access to the vehicles in both of our names. He told me I didn't pay for shit during our relationship and I didn't deserve anything, which is not the case. He continues to exert control over my financial abilities. He refused to work with my attorney to remove me from shared loans. While my attorney was retained, Mr. Moritz tried to impersonate me on the phone with her, refused to talk to the investigator my attorney hired to contact Mr. Moritz after this incident. I have a declaration from the investigator stating, "I'm not signing a fucking thing. If the house sells, she gets half." He has now allowed shared property to go into foreclosure and repossession, which has prevented me from being able to move on and purchase a stable home for my child. He has lied to the court and refused to cooperate with the legal process. One example of this is his repeated attempt to manipulate by claiming I had tax documents he needed. Upon hiring his attorney to help him gain the documents I was supposedly keeping from him, his attorney never sent me any requests for these documents, even though it was stated in court that there would be a letter sent to me that would be added under the criminal case. I do not have any legal documents. Mr. Moritz could not obtain copies of himself. The documents I have are mortgage loan documents and our 2024 F-250 loan documents, both in my name. Mr. Moritz also tried to buy propane under my credit card in January 2026. When I called and asked Northwoods Propane about the incident, she immediately apologized and said, "I'm so sorry, this is a card he said it was okay to charge to, but I'm returning your money immediately." This might be Mr. Moritz's first time with charges, but he is not a first-time offender. Mr. Moritz has multiple CPS cases from his children, a couple of closed cases with his adult children, one closed case with my son in 2021, the latest one with his youngest son and him being removed from our home immediately in October 2023, along with CPS being called again in November 2023 when Mr. Moritz threatened my son. Mr. Moritz refused to do anything to cooperate in the most recent CPS case. He did not go to court. He did not go to any meetings, and he refuses to do anything to regain visitation with his son to this day, but continues to harass his son's mom, Terry Moritz, in the situation and blame everyone else for his shortcomings. Also stating to me he would rather pretend his son is dead than do anything to fix the situation. There are also 3 cases where Terry Moritz had to call the cops on Mr. Moritz for multiple reasons, including harassment, a safety check on his youngest child, and domestic abuse harassment, which he wasn't charged. I would go even further to call him dangerous. He knows exactly how to act, in front of who and when. His thought process and how he believes and perceives the world is scary. He told me more than once that I deserved my abuse, and the only reason I can get him in trouble for what he does is because I have a vagina. His children deserve their abuse. But he did not refer to it as abuse when he was speaking about me and his children. In his mind, he was defending himself, proving a point, or his actions were just everyday life. He always states he never does anything wrong. Mr. Moritz once told me he was like a god and should be treated as such. And I should be washing with his feet with my hair like Jesus instead of running my fucking mouth. He also told me once he was born in the wrong generation. He should have been born back when it was acceptable to lock up your wives for disobeying. Since I moved from his home more than once, Mr. Moritz has tried to portray on social media and in text messages that I have been with him. He will post pictures on Facebook and send me random text messages stating, "If you're still here, will you feed the dog?" I asked him to get help multiple times for his mental health and alcoholism. He believes he does not need help. He likes who he is. I've watched him walk into this courtroom via video multiple times and lie to the court. The extent of his disregard for the law in this case, continuing to treat Mr. Moritz as a first-time offender when he is not, has only strengthened his belief that he is above the law and that his actions and legal violations carry no consequence. I fear that this setting is setting a dangerous precedent that will escalate his behavior for even further in the future. He has shown that he does not respect the law, the courts, or law enforcement and believes he can avoid all consequences. Mr. Moritz will not stop on his own. His ex-wife, Terry, who I've referred to multiple times in this statement, has not been in a relationship with Mr. Moritz for 7 years, yet he continues to harass her in different ways. There has to come a time when my child and I can stop walking on eggshells and looking over our shoulder every time we leave the front door of our home. For the safety of myself, my child, and others, I ask the courts today to see the bigger picture of Mr. Moritz's past and current actions, holding him accountable with consequences stronger than monetary. I would like to request 60 days upfront jail time and 1 year of probation. Thank you for your time and consideration.
And just so I have all the facts in my head. Well, Mr. Moritz, do you share a child with BJR?
No.
No. Okay. So
I raised her son since he
okay,
was
so
5.
I just wanted to make sure. I
No,
just wanted
yeah.
to see that. Okay.
His father's Bert Barnes.
Okay, so I have in front of me that plea questionnaire waiver of rights form. Do you have that? That's that document in front of you, Mr. Moritz?
Yes.
And is that the document your attorney went over with you?
Yes.
Did he go over it thoroughly with you?
Well, as much as I can understand. It's all gibberish to me.
Well, as much as you can understand. So did and I'm going to guess that you had questions for your attorney and you said, I don't understand that. When you said those things, did your attorney then explain it to you more?
He did, but
And
in my mind,
Mr. Moritz, I'm stopping this. I'm not going to let you make statements and say, I don't understand this. I don't understand this. I don't understand this. Because if you're telling me that, then I'm going to have to order a competency evaluation, okay?
Yes.
Because I need to make sure that you're competent to enter a plea. You're competent to be here today and to have these charges brought against you. And so if I'm hearing from you that even though you're a learned attorney who's went to law school, who's practiced for many years now, if I'm hearing that he was unable to explain the words on that document to you thoroughly so you can understand.
he did. Yes.
He did.
Yes.
So there's no question. You understand everything on that document.
Yes.
Okay. And so with that, everything on that document, your attorney essentially read that to you word for word. Is that
Yes.
correct?
Yes.
And so you are telling the court that even if you didn't understand something at one time while he was going over it with you, you asked him the questions until you fully understood everything on this document.
Yes,
Now, coming to court here today, that document as well as the post-conviction document and whether or not you wish to appeal was placed in front of you on that table, correct?
yes,
And you had an opportunity to review and read that thoroughly, correct?
yes,
And you can read, write, and you understand the English language.
yes.
Now, how many years of schooling do you have? Do you have an HSED, GED?
I graduated high school and I went 2 years to Dakota County Technical College for mechanics and machining.
Excellent. Okay, so you have more than just a high school education.
Yes,
Okay, so you can read, write, you understand the English language, so you understand this document and you reviewed it and read it thoroughly again when you got here to court.
yes,
And then did you sign those documents?
yes, I did.
So you are 50 and you are pleading guilty to one count of knowingly violating a domestic abuse order, correct?
Yes,
And you are not receiving treatment for mental illness or disorder, no AODA services or anything, because those kind of count as that. You've not had any drugs, alcohol, or medications within the last 24 hours.
no,
You have not?
No.
Zero,
0.
24 hours. All right. Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes,
Did your attorney thoroughly go over with you the maximum possible penalties you face?
yes,
And so you understood those when he went over that.
yes,
Now, because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that first page in the middle of that document. It's bold and says constitutional rights underlined.
yes.
Okay?
Okay,
Now, do you understand that by entering a guilty plea, you're waiving and giving up those rights?
yes,
Do you understand you'll no longer have the right to a trial? You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or remain silent and not have your silence used against you. You will no longer have the right to a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights?
yes,
And you understand you're giving those up?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
right, yes,
Do you understand? The state would have to prove as to count 1 in 25 CM 113, knowingly violating a domestic abuse injunction, that on or around June 13, 2025, in Burnett County, Wisconsin, you knowingly violated an injunction in Burnett County case number 24 CV 120. Do you understand what the state would have to prove? They would have to prove that there is a domestic abuse injunction, right? First thing, right? Understand that?
yes,
And they would have to prove that you violated that injunction somehow, and here having contact with the petitioner, correct? Yes?
yes,
And they would also have to prove that you knowingly did so, meaning that you knew there was an injunction and you knew you weren't supposed to contact her, correct?
not the first few times, but I did contact her after I didn't realize texting was illegal, to be honest, but
It's a contact. It's a form of communication.
I didn't
Okay,
understand
but
that.
here's the thing. I'm not asking if you did it right now.
Right.
And having you tell me when you did, when you didn't,
Right.
what you understood and what you didn't understand, okay? What I'm asking is, do you understand what the state would have to prove in front of a jury or to the court to find your guilt?
Yes.
Yes. All right. Do you understand the maximum possible penalty for this crime could be a fine of no more than $10,000 or imprisonment of no more than 9 months or both? Do you understand that?
Yes.
Now, do you understand that there's an agreement here? And please recite it again, Mr. Rosenthal. I just want to make sure he understands it, the court understands it, we all understand it.
Your Honor, both parties are going to be free to argue sentencing. I will address those arguments when we get to it.
All right. So it's a free to argue. So you understand that?
Yes.
And so I guess it's not probation, it's not jail, it's not any of these things. It's a free to argue. And you understand that?
Yes.
And I'm guessing that's because of the negotiation back and forth, because one of the offers was to plead to 2 counts and all these things. And your attorney wheeled and dealed and negotiated on your behalf, and this is the end result. Do you understand?
Yes,
And you were working with him on the sidelines, telling him things, and he was telling you things, right?
yes, ma'am.
All during this negotiation process.
Yes,
Okay. And so you understand that offer. Do you understand in the agreement that you reached? Do you understand I'm not bound to follow anything that is argued or recommended by the state?
yes,
I'm not bound to follow anything that's argued or recommended by your attorney. You understand that?
yes,
I am free to sentence you in what I feel in my discretion based upon all of the facts of not only this case, but the other cases, because they're being asked to be dismissed and read in. Do you understand that?
yes,
So that means if I feel in my discretion based upon the totality of the circumstances, looking at you, looking at the cases, looking at the facts, that it should be the maximum possible penalty, that's my discretion and I can sentence you to that. You understand?
yes.
Do you still wish to proceed and enter a guilty plea?
I have to talk to. Yes or no?
No,
Well, Lee,
Do you-
I mean, we talked
do you
about
have
this
a
pretty
question?
thoroughly.
you went over it pretty thoroughly with him.
Yes.
We did. We had a number of discussions. I mean, this was the intent walking in here to plead guilty to this. I mean, I hope you've ever understood everything here, Lee, but I mean, this is kind of was explained in great detail. I mean, if you want to withdraw your plea, I guess now is the time, but I was under the impression that we had an agreement.
Your Honor, I am guilty from text messaging.
All
That's
right.
it.
And so
I
that's what you're
admit,
saying. You're admitting your guilt.
I did. There's proof.
All right. Okay. And so you understand the agreement and you understand that the court's not bound to follow anyone's recommendation. You understand that?
Yes,
And so you wish to proceed and enter a guilty plea today.
yes,
Now, did you go over the facts of the criminal complaint with your attorney? And those are the facts on that original charging document that basically say what happened and why you were charged with these crimes. You remember that?
yes,
Now, for the most part, as it relates to the charge you're pleading guilty to, those text messages, that communication and violating the injunction 24 CV 120, are those facts accurate?
yes,
Mr. Rosenthal, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Are you admitting guilt here today, Mr. Moritz, because you are guilty?
for text messaging, yes.
Yes. I mean, you can try and pass it off any way you wish and try
Yes.
and,
For
pass
te-
the buck, but it's,
No, I didn't understand that no contact I thought was physical contact. I didn't understand that text messaging was
all right.
out the
And-
window.
And here's the deal, and I'll swing right around to there, because I want to make sure you understand everything, because that's my job, is to make sure you understand everything. You're voluntarily, knowingly, and understandingly, intelligently entering this plea. Now, in the 24 CV 120 case, BJR versus Lee Moritz, and that was filed September 19, 2024, with a temporary injunction restraining order granted. Now, and a hearing was scheduled, and there were arguments made on the record that you were evading service and that they tried all means of service and they had to resort to publication, okay?
In court, the truth doesn't stay buried forever. One guilty plea can expose years of pain behind closed doors. And sometimes, accountability arrives all at once.